Good morning, ladies.
Yes.
Good morning, Victoria.
Good morning, Victoria. It's nice to see you all.
Welcome, Lillian. And Roy Brown is still connecting.
Good morning.
Good morning.
Yes, busy week this week. Everybody's getting ready for back to school.
Okay, welcome, Roy.
Hi, Roy. Nice to see you.
Good to see you, Felicia.
Nice to meet you.
Nice to meet you.
I understand that you're brand new and a new role at Felix.
Yes, it's our first, I'm the first HR manager here, so it's been fun.
Great.
Yeah, it's a big role, right, Roy? And a necessary role, right? So you guys just, yeah.
Well, you'll have lots of support here in the community. So we have had a number of people register for the event quite often because we do send out the recording post-event that a lot of people will register so they get that recording. And we understand today is a busy day with students coming back to the workplace. So we're going to go ahead and get started a little bit about our podcast, particularly for you, Roy, because I know this is your first time here, is that Felicia and I both get a lot of questions from school districts throughout Southern California. And we would oftentimes confirm, and I finally said, well, I already do a podcast. Why don't we do one on these topics too? And so we've been at this now for well over 2 years, I think. I think we started early 2021 and been going strong ever since. We take July off. So this is our first podcast after the summer break, and we'll be going through to December. So we usually pick up 4 topics every week or every month. And we try to stay on top of what's hot and also related to the questions that we're presented with and trying to bring back meaningful information. And the 4 topics are chunking it down when multiple conditions exist, but at different stages of recovery. Number 2, the best course of action to take when employees are not back to work. And certainly we're flooded with those kinds of issues right now with school resuming. Number 3, meeting the 60-day time frame, the implications, consequences, and outcomes. Number 4, the mental health crisis and its impact on timely psych evaluations. So we are going to get ready here. So one of the things that Felicia and I often question with is, what do you do when somebody has multiple work-related injuries and they may be at maximum medical improvement for one, but not the others? And so, Felicia, I'll let you take the lead on answering that. I know the answer, but let's start.
We have a few really interesting examples that I thought I would use that are real from some of our school districts. And when employees have one workers' comp claim, but they have multiple injuries. And we have one example where we have a shoulder injury where an employee injured their shoulder in workers' comp, and they also have a psych stress component attached to that claim. What happened was the shoulder had surgery and follow-up rehabilitation, and the orthopedic doctor for the shoulder injury made the employee permanent and stationary, which means maximum medical improvement in our work comp lingo, for those of you that are new to our terminology. And that came with permanent disability rating and permanent work restrictions that were sent by our claims administrators to the school district. But then there also is a psychological aspect to the claim. And the psych doctor does not feel that the employee is permanent and stationary yet. And is still under treatment and weekly counseling, but has given the employee some temporary work restrictions that need to be modified under the return to work program on a temporary basis. That created a lot of confusion between Athens and the school district. Athens was saying, you don't need to meet until everything is permanent and stationary, but that's a workers' comp rule. That is not an EEOC ADA FEHA rule. And the IPM process, the interactive process meetings, and the accommodation process is different from the workers' comp process, right? So we want to stay firmly in that world. And Deborah, the language there is within a reasonable time frame of knowing about these limitations that you're interacting, right? So, the litigation on that is failure to meet, failure to engage, failure to accommodate. So we don't want to do any of those things. So we want to be very proactive and very timely. We never want to wait on any permanent work restrictions, regardless of how many body parts there are or what status they are in the workers' comp system. So the recommendations to the district was go ahead and schedule the IPM meeting either on your own or with a moderator such as Dr. Dupree, and discuss the permanent work restrictions that you have from the permanent and stationary report for that shoulder. Then you're also going to discuss, right, Dr. Dupree, in that meeting, the psychological temporary work restrictions, because you also have those that either may or may not be able to accommodate. And I think that goes to your chunking it down process, right?
Yes, absolutely. And a couple of things about that too is similar to that is that I just did an IPM a couple of weeks ago where we had done an IPM back in August of 2022. Again, a situation of where there's been a couple of different claims, multiple body parts, and it was quite confusing last year because we had several medical reports that all had varying limitations. A couple of doctors said no limitations, and then another doctor, the QME, said a 10-pound lifting limitation, while another one said 20 pounds. And so, she did go back to work, did ergonomic evaluation, but for reasons I'm not clear about, she saw the QME again. And there are some new limitations that are different than what we did with last year. And so, in fact, they've become a little bit more limiting. And so we met in order to evaluate, can she still safely work? There are some concerns about maybe her aides being given too much of the lifting, and we'll see about that. But I've recommended that if there are any other challenges that develop, it would be, I think, in the district's best interest, as well as the employee, to go through an independent fitness for duty, because we've had such a wide array of medical opinions, and she readily acknowledges she has a high threshold for pain, and so she's gone back to work earlier than what her doctors have recommended on several occasions. And so, to me, that's a risk factor for direct threat to her, and also potential injury to the aides. Although she is in a moderate, a class with special needs for moderate level, and so they're mostly, more intellectual academic learning challenges and not the physical aggression we might see in the mod severe. And so it's like, okay, can breathe a sigh of relief there a little bit, because she's not quite in the same environment. That would be of more concern. But I am concerned that she's,
Pushing
still seems to be
herself.
worsening a little bit. Yeah.
Pushing a little bit. Well, and our employees like to return to work, right? That's the goal. And so sometimes that can happen. What was an additional complicating factor in the example that I gave was the psychological temporary work restriction was not being able to work around their current supervisor, at or around. And I almost believe, Deborah, it was not at their site. So they couldn't work at their site, and they couldn't work at or around their current supervisor. And then the district was just stymied before the IPM. They said, what are we going to do with that? And I said, well, we're going to talk about in the IPM meeting, you're going to start with the shoulder and the permanent work restrictions and whether or not you can accommodate that. That's the chunking it down, right? And then you're going to talk about and whether you can perform the essential functions with the shoulder had some lifting and pushing and pulling restrictions that the district felt that they could probably accommodate within the current job. They thought that they could. But then you had the temporary work restriction, and it's one person, even though there's two body parts. We still look at them as a whole individual. That no working at or around the supervisor was really problematic. And then when you add on can't work at the current site, then you're talking about moving to a different site. Then this becomes very problematic. And they got very confused. And that's why I said you probably do need a moderator to help you now, because this is really confusing, because they were saying, what if we can accommodate and I'll throw this question back to you because their question was, well, what if we can accommodate the shoulder permanent work restrictions, but we cannot accommodate even temporarily this restriction of no working at or around their supervisor. This is their current supervisor in their position who supervises that whole department and at that current site.
Well, that sounds similar to another one I had about a year ago, where he couldn't, he couldn't work. Well, the same supervisor managed several sites. And so no matter where he went, he was going to encounter the same supervisor. Yeah. Yeah. And I have another situation where it's a psych situation, doesn't have a corresponding orthopedic complaint, but is precluded from being near or around the program director, as well as the assistant superintendent who oversees
Very
that.
problematic, right? That's
And so we basically, after a long discussion, trying to sift through what are the challenges, and for what people have changed, so nothing had been done at a higher level. But we eventually went back to the employee and saying, if your doctor said limited to no contact, that's something. But to say no contact, we can't guarantee that if you're working in the program where you have to have meetings.
yes.
And so she said, well, I could probably be around that person as long as there are other people here. I said, well, then your doctor needs to write that, because right now we can't bring you back. They've been accommodating her and we've agreed to extend the accommodation while we sort this out. But if it really means no contact, then we can't prevent that from happening when you're working in that department.
Have you seen examples in your IPM meetings where if they can accommodate the permanent work restrictions for the shoulder, do you go ahead and make a letter offer of return to work on that? And then under the temporary work restrictions of no working at or around the supervisor or no working at that site, either one or both of them, which are problematic, that they might not be able to come back under those temporary work restrictions, until they're changed or until the permanent stationary psychological report comes in.
Right. Well, based on my understanding, and I did have just a very recent discussion with the claims examiner at Athens, that if one medical condition has been determined, maximum medical improvement, just by workers' comp with the notice of offer, you need to evaluate that the ability to accommodate either through modified or alternative employment. Otherwise, you face the risk that you haven't addressed the return to work possibilities for what could be different claims or different body parts. And so somebody could be accommodated for like in this particular situation we were talking about earlier with the orthopedic, then we should address that, make the offer, but whether or not the employee starts then is pending the resolution of other medical issues. And then it's questionable. Yeah.
Mm-hmm.
I would rather see districts be proactive so that they don't run the risk of
That's what I feel. Better to move forward and do what you can, especially if the situation is complicated, than wait, because usually it doesn't get easier with time. Not usually.
Yeah. One of the things I'll take this opportunity to request for all of you who use my services is that in sending the referral over, what would really be helpful for me is that if there has been a history of claims, then we really need to be aware of that, even if they've been accommodated before, because again, over time, if someone's sustaining multiple injuries in the same job, then that's suggesting that the person is at risk for further harm or injury by continuing to work. And so it raises questions that need to be evaluated in the return to work process. Okay, so the next one, the best course of action to take when employees are not back to work. And so this is where
I've been getting a lot of questions about this.
Yeah.
I'm sure you too, Deborah.
Well, the examples that we put out there are, particularly non-industrial illnesses where there is extensive absenteeism from the workplace, and particularly over multiple years. And whether a fitness for duty evaluation should be done or an IPM first, or just to get them to go to their private doctor to clarify. So I'd like to hear your thoughts on that. I know it's the non-work related are a little out, but
yes, I get a lot of calls, as you do too, for the fit for duty doctors, because a lot of our, not all, but a lot of our occupational doctors, some of them also do fit for duties for private fees. that are paid for, and the report and the fee are sent to the district for a fit for duty. So they'll call and they'll say, we have a long-term illness that's causing with a doctor's note that just says off work, right? And there's no information on modifications, limitations, return to work status, when it's going to end. And, we're back to school and they're trying to make plans for what to do with these people in these positions, because a lot of times it's causing issues at work, right? With staffing and with the other coworkers and the other teams in their department. And they don't have any information, right? They just know the person's been out for a prolonged, and sometimes there's been absentee issues even before this, right, Deborah, where they're out and back and out and back. And it's interesting. Some of them are psych conditions that I get the questions on, asking for fit for duty doctors. Other are back injuries, shoulder injuries, knee injuries, but it's kind of runs the gamut. And usually you're right. The comment that I make about the fit for duty doctors is it does take some time to get them scheduled. It is relatively expensive, right? It doesn't fall under workers' comp fee schedule, so it's private fees, and they contract and negotiate for those, but they're more, right? They're more than workers' comp, and then they also question whether or not. They usually don't think of it, but they question whether or not an IPM can be worthwhile without any more medical information. Why are we doing an IPM? We don't have anything but this doctor's note that says that they're off work. What are we going to discuss in an IPM? That's a lot of the questions that I get. And then the third is they'll throw up their hands and they'll say, well, it's going to cost too much and take too long to do the fit for duty process. The IPM is also relatively expensive, although it's cheaper than the fit for duty. It's less expensive than a fit for duty. And we don't have any detailed medical information. And we'll just send a letter to the private doctor asking for questions and clarifications. And this is their private group doctor under HIPAA, who you and I know is going to be extremely reluctant and non-cooperative with asking any questions, especially if it's a psych condition. You can almost guarantee you're going to get nothing from that. But I guess districts don't know that or don't understand that that's a hard way to go, right?
Yeah, there's a couple of things around that. I'll take the opportunity to elaborate on is that, under the ADA and FEHA, again, the idea of an interactive process is to evaluate what's going on from a medical perspective. It creates that confidential cooperative setting to do that. And if you get a note from a doctor saying you're off work, well, employer, you do have a right to know, well, what are the reasons that prevent you from coming back to work? We have an active return to work program. We want you back to work. What is it about your condition? Because without any knowledge, we don't know what to accommodate. And so by having the IPM, you fulfill your obligation under ADA and FEHA, and you also get a lot more information that you can work with then. And as I oftentimes like to say, as I open up a meeting, the meeting is designed to exchange information. We're sharing with you how the process works, at both the state and federal level. We're informing you about the guidelines. We're informing you about next steps if this doesn't work out. We're also informing you of the district's policy regarding leaves and extended leaves and, the education code. So it's an opportunity to educate employees about all of that so that they better understand where they fit in the process and some of their own obligation, because the ADA does say, the employee, if they're requesting accommodation and extended leave is an accommodation, then they have to cooperate in getting that information. And so the EEOC has also suggested that it is best to start with the employee's doctor. However, you need a consent to exchange information in order to do that. I mean, we can write to a doctor, but that doesn't mean the doctor's going to respond to us without that official written signed consent to exchange information. And I have a form that people can readily use, and it limits the information that we want to just the return to work effort process. Yeah. And so, but, giving the employee an opportunity to get information from their doctor in a reasonable time frame is not a bad way to start, actually. Give 2 weeks, not longer. And again, EEOC has said 2 weeks is sufficient. And so they have to be proactive in order to get the information for their employer. And then if that still doesn't work, then then an IPM would be in order before even going to the fitness for duty. So then again, the employee understands the context of what this is all about and why we're trying to do this. And so the other thing I will add to that is that chronic absenteeism on an annual basis also may result in the employee no longer being protected by the Family Medical Leave Act.
Mhm. Right.
And so to get FMLA protection in the current year, then you have to have worked at least 2/3 of your contracted hours in the prior year. And so when I hear of employees who have chronic conditions and they've had a high rate of absenteeism and near exhaustion of their 100 days for 3 years, we have a problem, Houston. And
Mhm. Right.
because if they can't meet the threshold of under FMLA, then they are too medically unable to engage in meaningful work. And again, chronic, well, let me restate that. Accommodations for chronic absenteeism, unexpected attendance, unexpected timely arrival is not something that should be accommodated per the EEOC. And so these are all red flags that people should be paying attention to. And this is where the right hand needs to be talking to the left hand sometimes.
Mhm.
And the principals and site administrators should also be informed of these practices so that they are not inadvertently providing informal accommodations that do become problematic in long term when it's not working.
Right. I did have a district that was wanting to send the letter to the private doctor asking for some questions and clarifications on their off work note that didn't have any detailed explanation or information, but the employee refused to sign the exchange of information consent. And I told them, you're probably 100% not going to get any response from any primary or private doctor in that circumstance, but you can go ahead and try if you want to and give your time frame for when you need the information back, but that's almost a guaranteed because of HIPAA and the primary and private doctors confidentiality rules about exchanging that information. They pretty much won't answer anything, right? There hasn't that been your experience?
Yeah, very much so, very much so. But that's where I find getting the IPM, getting the employee engaged in the IPM helps with that process. So because now they better understand the different laws that apply. They also understand the process and that, indefinite absenteeism from the workplace is a problem. And it may end up costing their job if they are out. And also, there's got to be fair application of the, provision under the Ed Code for the 100 days as well. Annually for the classified and one time for a certificator. And again, I just did one where they've had enough injuries or absenteeism, and it wasn't just for her condition, some family issues too. But she had, we see this not a lot, but we do see it where they're just at that threshold of the 100 days, ending, and then they'd go into an unpaid status, and then all of a sudden miraculously they're back to work, and so
Full duty release to return to work, right?
yeah. And so again, I find that IPM helps us explain that process to the employee and helps them better understand the consequences of mismanaging the process. So
right.
Yeah. So a couple things here, first of all, chunk it down, you break the situation apart. Too often we get, gosh, and but we need to, keep our logical mind there and break things down, and a timeline sometimes of developments on an individual situation can be very helpful to see the pattern and to see what's really happening. And then also, be mindful. One of the things we talked about back in June was doing an end of the year and then a beginning of the year review. Where are our employees who have medical conditions, work-related or non-work related, so that we are not doing indefinite leaves of absence or accommodation without checking into the situation. And so that's where, taking a look at our number 2 issue, when somebody has a lot of absenteeism, then how do we manage that? Of course, I'm an advocate of IPMs. I've been doing them since the ADA was implemented. So I know the power that they have. And just encourage, it's a proactive step, and it covers your back, shall we say.
Agreed.
Okay, we've seen this one a lot too lately,
Mhm.
missing the 60-day timeline under workers' compensation. Um, what happens? What are the implications, the consequences and outcomes when, let's say, just untimely action getting and addressing the issue, or let's say an employee is delaying, dragging their feet out about something. And I'll let you stab at that one, Felicia.
We've seen a lot of this right now. Many districts are running close to the end of the 60 days or even at the end of the 60-day time frame. We'll talk about that time frame in a little bit because I did some background just to go over that. Because employees are either off contract and they don't want to meet because they're not, on contracted work time, which can be a policy issue with individual districts. And also sometimes they're saying they need more time to meet and confer with their union rep or with their attorney before holding, and sometimes this delays scheduling the meeting. So even the district is trying to meet the time frame. So I wanted to go over a little bit the 60-day time frame and sort of the implications of that. And then we could talk about the consequences for employees. And this is on the comp side, not on the ADA EEOC. This is the work comp rules now. Employees that are injured after 1/1/2013, which is most of the employees that we're talking about now, with injuries that result in permanent disability. This is an important little factoid. If you don't have any rateable permanent disability, there is no obligation to provide a $6,000 retraining voucher. And we'll go into that in a little bit. And whose employer does not offer other regular, modified, or alternative work may qualify for additional benefits under the supplemental job displacement benefit. We call it a voucher, but that's the official term, is the supplemental job displacement benefit. The offer must be made within 60 days after receipt. There's lots of questions. Is it the date of the doctor's final permanent stationary report? Or is it receipt? It's the date that Athens received the report is when the 60-day clock's starting. The voucher amount is $6,000. It can be used for training at a California public school or any provider on a California eligible training provider list. It can be used for testing fees, tools, buying a computer up to $1,000, buying up to $500 of miscellaneous expenses getting reimbursed, up to $600 to pay for vocational counselor for retraining. The voucher is due, the Athens has to pay that 20 days from the expiration of timely employer making the offer. The job must pay no less than 85% of the worker's earnings at the time of the injury, not at the time you're doing the meeting. And it must be expected to last at least 12 months. So, and that offer of modified or alternative work also has to meet, the employee has to have the ability to perform the essential functions. We already talked about the job is a regular position. It's not a made up position. It's a regular position and it lasts at least 12 months. And we talked about the wages at least 85% at the time of the injury, and that the job is located within a reasonable commuting time frame. Some of our districts have made alternative and modified job offers, but they've had to commute further, and sometimes we've had to offer the voucher anyway. And it's also distance from your residence at the time of the injury. So there's specific wording on that. And obviously, the idea is we want to try to meet within the 60-day timeframes, so we're not running to the end. And obviously, the voucher has to be offered if you're not going to be able to make an offer of in their regular department, in another department, modified, alternative position. And also, even if you do make an offer, but it doesn't meet all this criteria, Athens may still have to pay the $6,000 voucher. And I think, Deborah, you've seen some examples of that also. I've seen the commuting example come up a couple times now, and that the job's not at least 12 months, that it's like a temporary position that's not going to last very long. And sometimes it doesn't meet the wage criteria. That does not mean that they can't accept the position though, right, Deborah?
Yeah, that's that's been a big confusion as far as because I did have a claims examiner just say last week that you can't offer it if it doesn't meet 85%. Well, let's clarify that. As an employer, you can offer the employee any job that they may be qualified for and can physically perform. The ADA doesn't have the same requirements as workers' comp does, but and I've seen employees accept it because they want to continue working. And I've seen people accept temporary jobs because they want to continue working, and it gives them, they're employed while continuing to look. And so again, you can make any offer, but if it doesn't meet this criteria, the employee has a legal right to decline the offer. But then that means they're out of a job, at least until they find something else. Yeah. So again, the thinking about it is needs to be flexible in terms of taking a look at those things. Yeah. Yeah.
And I think you just have to do, I know some districts have new HR staff, and we've had some people retire from districts that were there for many, many years. And so we have a lot of new folks starting July 1, and they've had a hard time because the 60-day time frame, maybe there was only 10 days left, or, they're running out of time. The sands are running through. And I think you and I, our recommendation is always do the best you can to meet the time frame. But when you are trying to get union reps in, and sometimes they want their attorney in, which means our attorney needs to come in to balance the table. We don't want employees to have representation, but the district doesn't have representation there. We do not recommend doing that. We've had some attorneys really try to take over the whole meeting, so it can be difficult, complicated. And then we have seen lots of IPMs where 2 or 3 union reps are present, and they can get very, complicated.
Yes,
quickly.
yes. I know I just did an IPM early last week, and even though the employee had been provided with an overview before we had the meeting and agreed to the meeting, then he started raising noise as far as, well, we're talking about my legal rights, and I should have my attorney here. And I said, well, actually, this is about return to work, and I'm explaining the laws under which the return to work process exists. We're not talking about your legal rights. We're talking about the legal requirement. If you want accommodation, this is how we do it. And I said, usually attorneys do not participate in these. You're welcome to bring them, but they're not required, because we're not discussing your claim, particularly if it's a workers' comp attorney. We're not discussing the claim. We're simply addressing the outcome of the employee's recovery for return to work purposes. And their employment law attorneys may get involved, and we definitely then want legal representation for the district then, because that gets into other issues.
Yes.
And sometimes I've had employees bring up other issues related to harassment or discrimination, and I have to redirect that. Well, that may exist, but that's a different form. Right now, we're here simply to address the return to work process for your medical condition. I just had that come up in a week or two ago too. So a lot of these issues are really current, right?
Yes. And I have had a couple of the districts say that during the IPM meeting, sometimes they were doing it on their own, and the employees started asking a lot of questions about, I'd like to see the citation about your return to work program. So I always recommend that districts have that ready. That should be ready, because I know some districts will tell me they just go through the process of looking at the job description and the essential functions, and then say, we're not going to be able to accommodate, these permanent work restrictions or limitations. But then they don't do the part 2, where you have to go through, you have to have HR there, and you're going through every open position, right? And then you're going through leave, and then you're also talking about your, return to work policy that every district in school should have, with a uniform policy on how long you provide temporary accommodated duty. Some of our districts have policies of 90 days, right? Some have 60 plus 60 to a maximum of 120. That's probably the most popular policy. And then some have 90 plus 90 to 180 of temporary accommodated leave. That's for illness, non-industrial sick, and for workers' comp, because you should be handling your disabled employees the same. You shouldn't be discriminating or treating. Some people will tell me, oh, I only do my return to work program for my work comp people, but it should be for all your disabled people. It's not a workers' comp return to work program. It's a return to work program that's really under the ADA and FEHA and EEOC.
Right. Yeah. And a caution to any employer who may listen to this, that doesn't have a return to work program for all employees with medical conditions, therefore you are actually discriminating against those who have medical conditions that aren't under workers' comp. It's differential and disparate treatment. And that is a claim under the employment provisions of Title VII. And so we can cross the line there. I do want to just wrap up on number 3 about the 60-day timeline. What we have seen, again, making sure, I know I've changed my referral form that districts complete to include the date of the MMI, but also the date Athens received notification.
Mhm.
And normally, if Athens is doing the referral, they will normally do the form themselves. And so then I just quickly confirm that that is this the date that you received notice? Because now we need to start the 60-day clock and know how much time we have. And I know scheduling can be difficult, but last year I know that for reasons not clear to me, but there were 2 employees actually married, working for the same school district, who both had injuries, and they were not evaluated in the 60-day time frame. Guess what? They both got their $6,000 job retraining monies, and they're still working.
And I
Where
think
they're
they
still
were
working.
accommodated, right? They were
Yeah,
permanently provided permanent modified duty, and Athens had to pay the $6,000 retraining
right.
voucher, which
Yeah.
could mean you get
So
a free computer and $500 of expenses, right?
yeah. So it's a lot of money. When you're talking about that, I'll just go back then. Is that having an IPM is far less expensive than paying the voucher.
Mhm.
We can get this cleared up. Yeah. Okay, so now, one of the hot topics that it
Oh.
really has emerged, always been there, but and being a licensed marriage family therapist in my earlier career as well, the viewpoint around mental health crises is very different than it ever used to be, and really hitting headlines in all kinds of fronts, and certainly impacting our return to work efforts for employees. And so, what's been your experience, Felicia, of recently?
We have really, really struggled. So we have our own medical provider network on the work comp side, right? And those are the physicians that are contracted to treat our injured employees with mental health, or what we call psych stress work comp injuries, right? But a lot of them also will do fit for duties for districts that are having challenges with employees on the non-industrial side that's affecting their ability to perform their essential job duties. The mental health crisis, as I call it, is access to care. It's a mental health crisis within our employee population, both workers' comp and on the private side, but it's also access to care crisis where we don't have enough psychologists and psychiatrists. And then what happens because of that is they're getting backed up. And you guys have already been feeling that, right? When we have a psych stress claim, we want you to send them to an occupational provider right away, right? As soon as they file the claim, they still go to OCMED because it's going to take us a few weeks to get them in anywhere. And you know what OCMED is going to do? Yes, they're going to see an MD or a DO, and they're going to evaluate them, see what kind of status they're in, usually give them a work status, and then they'll tell us, like, is it urgent? They need to be seen right away. And do they need a psychologist, or do they need medication and need to see a psychiatrist? Because now we know that psychiatrists don't do counseling anymore. We know that. And psychologists don't do medication. So sometimes you need both. You need a psychologist to do your weekly counseling. And you knew before, Deborah, for years, you did both. You went to one psychiatrist and he gave you your medication and he did your counseling. But now that is no more a thing because they're too busy just monitoring medications. They could barely stay up with that. So as an example, Dr. Takamura, who is a psychiatrist, he also performs fit for duties for many of our districts. And he's, I think, in the Poway area, right, Deborah? And he also monitors medication does workers' comp for our work comp side. But he's very, very busy, right? It takes weeks to get into him. And our psychologists that we use a lot, like Dr. Ray and Dr. LaPalooza, it's taking weeks to get into them also. And we are adding a Concentra just hired a new psychologist only in the Kearney Mesa location, who is there part-time seeing psych work comp. She just does workers' comp. That's all she does. So that's been a help too, because many of you use Concentra. So if you have a psych case, sometimes if you go to Concentra, then they can refer them in to this psychologist that they have just to treat their work comp injuries, because of employers having this problem with delay, because it's a double problem, right? We already have the mental health issue going on, and then we're not able to get you care right away. So it's almost impossible, I will say, unless I call in a big favor, to get somebody in a week or two for a psych stress claim for workers' comp. It's going to take longer than that just because of how impacted they are. But we in the claims team at Athens and on the comp side do our best. We have had some fit for duty situations where the districts will contact some of these psychologists and psychiatrists to do fit for duties, and they'll give them a date, whatever, 2 or 3 months out. And then they call me back and say, that's not reasonable. How are we supposed to wait 2 or 3 months? We have a performance issue with an employee who's having mental health issues that are showing up at work. We can't wait 2 or 3 months for a fit for duty. And they'll kind of call around. I'll give them many different options, but I try to explain to them, you can't, it's unreasonable to expect that you can get somebody in for a psych eval, for a fit for duty, or for workers' comp within probably a 2 or 3 week period. When you say that now is no longer a reasonable time frame because of the problems with access to care.
Right. I know that sometimes it's discussed as far as taking the employee, if there's concern about the employee's safety or to the safety of others, like in a mental health issue, then that may be best to then implement a paid leave of absence, in order to address the safety issues. And it may not be the most desired way, but then the rationale that I've received from some of the district offices is that, if something should happen and then there's knowledge that we knew about this and we kept them working, we'd have even greater liability,
Right.
if something were to happen. And I oftentimes will share with employees when I'm involved is that, in today's work world, not even just our work world, but in today's life, there's so much danger possible. We certainly have seen shootings at schools and things like that. We're not saying that that's what you would do, but again, we can't afford not to be cautious here and take a proactive approach.
Right. And when we have urgent situations, because we have had a couple of injured employees that were suicidal or had suicidal ideation, that is a call to me. I've got back channel into these doctors, and they will move things around for emergency situations. Usually that involves coming in on a day off or seeing them on a day that they wouldn't normally see patients, right? And that's what I call calling in a favor. But we do that in urgent situations, and we also have access into the EASE Evernorth program, and we can use that. Those reports are confidential, and they are not shared with Athens if it's a work comp. But if it's a non-industrial situation, certainly we want them to have access into EASE or also their EAP program, because the EASE Evernorth is 6 no-cost visits. And those can be done, face to face. Those can be done the way we're doing this meeting right here. They can be done virtually. And then now they even have the chat and talk to text options for people that like to have flexibility about the way they have those services. And then obviously those that are benefited employees, EASE, it doesn't matter if they're benefited or walk-on coaches or substitutes. It doesn't matter what class of employee they are for you, because I just report all paid lives. But they also may have access under EAP, and we want to make sure if it's non-industrial that we go that way. Even if it's an industrial claim and it's taking a while to get them in, certainly they can start that process. It's just that information won't go into the claim file, right? Because that's completely confidential. EASE and EAP, they don't go
Right.
Those notes don't go into any place to anyone, right?
Right. I have a question for you, Felicia, because what you were just talking about generally sparked my interest on something. I'd like to hear your perspective, and maybe this would be beneficial for our audience. I have an employee who is off for several months due to a mental health issue, and then requested accommodation And so one was made, but it was, I have to admit, it was quite abused by the employee, and of course couldn't get much more specific information from her provider. But it was subsequently learned, because of some other involvement I had with that district, that the employee wasn't even in active treatment for her mental health condition. And I was like, that you're claiming an accommodation for something you're not treating for. Help me understand how you get better, you know?
Right.
And so,
There's
and
no
so,
improvement, right? There's no treatment,
Yeah.
no improvement.
yeah. And she hasn't been determined maximum medical improvement either. So it's
Oh.
like, yeah, this is, it's
And that's a
odd.
work comp claim? That's a work comp?
No, it's
Oh,
not.
that's a non-industrial situation. Yes,
Yeah.
because obviously I know we say, it's a river, that the notes flow and the IPMs change. But if there's no treatment, and then you would almost assume, is it a permanent condition, right? Then you'd have to have
Mhm.
clarification from a medical perspective, because I consider, if you're not treating for a condition, is it permanent? That's the time to ask the doctor, are these restrictions permanent? Because if you're not treating them, then how are they going to change or improve? Is
Yeah.
this, is this something we need to look at as, are you now saying it's permanent? It's never going to change, it's fixed. Because that's kind of what we do on the comp side. If you're not in treatment, then we ask the doctor, okay, they're not treating anymore. Can you do a permanent and stationary report and give us the permanent disability and the permanent work restrictions? Because there's no treatment, there's no movement, there's no change, there's no river, there's no flow in the IPM, right?
Yeah.
I did want to add one thing on the psych, because we did have a district that had an employee with a real mental health issue that was happening on the job, that was what you were talking about, a danger and a liability. So they took them off on paid administrative leave while they're working on the problem. And it's interesting, though, I think they've tried to schedule 2 or 3 different appointments with different psychologists and psychiatrists that do perform fit for duties and treat our work comp employees. They're very familiar with our employee situation. And the employee was so hostile and difficult with their staff that the doctors ended up refusing to see this employed live. So the one thing I do have to tell you, this becomes very difficult. They have staff and employees too, and they have an office that they're responsible for. So if your employee can't even be professional enough to go through the process, they can refuse to see them, both on the fit for duty side and on the work comp side. And we don't get mad. And that is not a violation of the MPN, because every physician has the right to refuse care if they feel that that person could harm the people in their office. Right. And obviously this is their business, their chosen profession. So they know there's risk, but they have people in their front office and gals that answer the phone and do their billing, and they don't want to subject them. There's a certain level. And if your employee goes beyond a certain level, they're not going to see them. And so they keep telling me, give me another doctor's name, give me another doctor's name. But it's a real problem, because they're on paid admin leave while they work out this non-industrial situation. So I have a lot of empathy for the situation, because it's really difficult. They need to get clarification on whether it's safe for have them at work, and they agreed to do paid admin leave to take them off work while they're trying to get this clarification. But the employee won't behave in a professional enough manner to even be seen in a doctor's office. That's a conundrum.
Yes, that is. One of the, I'll just add before we wrap up here, is that be mindful if you're hearing about changes of behavior in your employees. That is another time to, again, I would use the IPM as a confidential way of exploring with the employee the observations and concerns that have been generated, and explore what might be going on for them. So changes in behavior is a real big, again, red flag to do something about it. I've had several cases, and I've got one going on right now, where there has been a gradual increase in worsening of behavior and performance. And so sometimes, particularly as employees are older, they may start developing conditions, like Alzheimer's or something like that, could be a problematic. And I know for one employee, she was insisting everything was fine, but there were numerous accounts of problem behavior in the workplace, and which is putting the students at risk, given her position. And it's time to talk. Is basically what I'm trying to say. It's time to talk, have a conversation with the employee, share the concerns, and again, either allow them to go back to their own doctor. And in this one case, it was found she had a condition that she wasn't even aware of, and so she actually ended up with early retirement as a result. Yeah. So, okay. Well, good enough. Well, we've covered 4 key things, chunking it down with multiple conditions, what to do when people are not back to work, the importance of meeting that 60-day time frame, and then also, the ongoing mental health crisis. And so, we got a little teaser for you for next month. And Felicia just found some, I don't know if I'll call it exciting new information, but some new information that could have dramatic effects. So
Yes.
tell them what it is.
For those of you in HR or risk that lives in HR, the EEOC unveiled their proposed regulations for the Pregnant Workers Fairness Act and the Pregnancy Discrimination Law on Monday. And then on Friday, they officially published the proposed regs. And so we will go over in our September meeting the highlights from those proposed regs, because there's some real changes about suspending essential job and functions for pregnant employees, and additional protections required under the ADA for protection of them. And so it's 275 pages, so we couldn't fit it in today, but we will talk about it in our next meeting.
Yes, very good. And there's been a lot of things coming out as far as what employers can and should be doing around mental health. And it's, as you can imagine, gaining much more prominence in today's work world. And so we'll continue to visit that and share things as we come along. Well, I want to say thank you to everyone who's here today, and I hope you got a lot out of it. And a reminder, a link to the recording will be coming out within the next week. And do share it, pass it on, and listen to it again. And more to come. We'll see you next September.
Yes.
Take care, everyone.
Thank you. Bye.
Bye,
Thank
everyone.
you. Bye-bye.
Yeah, I always
Okay,
worry that we're not
that
going to have enough material to fill up the time, but it never happens.
It never happens. Yeah. We both can have so many examples of what's going on. That,
Right. Yeah, that
Yeah.
was a Sweetwater case where, they called Dr. LaPalooza, and then his office wouldn't see the employee. Then they called Dr. Ray, but Dr. LaPalooza and Dr. Ray talked, and then she didn't want to see the patient. And then they called Dr. Takamura, and he said he would see the patient. Then the patient called the office, and then he said, no, my office is not going to see this patient. And I told them, you're almost in a situation now where you have to have the patient go to her own physician to get some information for you. And you're going to have to do something about this indefinite paid leave. You should never offer indefinite paid leave because she's not going through her regular sick leave, and you've taken her, they've taken her off work without a note, right, Deborah? So I said, you're going to have to meet and confer IPM and try to figure out what to do, because your idea of getting a fit for duty, it's not even about how long it's going to take. Nobody will even see this person because of how I guess difficult or caustic or hostile they are. So they said, well, what are we supposed to do if they're difficult and caustic and hostile? Isn't that what psychiatrists are paid to handle? And I said, not their staff and not their employees. And there's a level to everything. And our employees are expected to behave in a certain manner. They are, even if they're ill, there's still conduct that's required. So, and I said, but you can't agree to just pay admin leave forever. That can't be the way you solve it.
Yeah. I always advocate that it's got to be for a fixed time frame, for while, in a reasonable time frame in order
While we're doing X, right?
Yeah. And but the employer has a right to take somebody off if they have the, fear of risk for harm or injury.
Right.
For self or others, without a medical note, but they've got to be pretty clear about it. And I always encourage that they actually
do you do all the IPMs for Sweetwater, or do they just bring you in on the difficult ones? What are they doing?
Yeah, Jennifer had been doing a lot of them herself.
Okay, that's what.
But I wasn't called in on this one though.
Okay, that's what I didn't know if you were doing. So do you get called in when I know that Jenny likes to control all of it, right? Not
Mhm.
Jen Benavides, Jen
Yeah.
Carbucci likes to control everything. So they can do what they want, right?
Mhm.
Kind of.
Yeah.
Yeah.
Well, I haven't, I haven't had any encounters actually from Carbuccia, although she did refer to me a work climate intervention that I did last year,
Oh, good.
and yeah, and they were very happy with it. And so I think she sort of backed off on me. I
She
haven't.
has. She's backed off of the whole work comp and HR and is letting Jen handle things. So Jen might
Yeah.
handle the easy ones, and then I'm thinking she brings you in on the difficult ones. But yeah,
Yeah.
they were kind of like, well, don't they have to do fit for duties? And I said, no, they're like side work. That's not their
Yeah.
main. They kind of take them
Yeah.
on the side, right? They're kind of doing
Mhm.
us a favor, I guess.
Yeah.
They
Mhm.
were so funny. I said, they don't need any work. Are you kidding me? They're buried with work. They can't handle the work they're getting. The only reason that Dr. Ray can get people in more, and it's interesting, the claims team likes Dr. LaPalooza better than they like Dr. Ray, because they think Dr. Ray, because you know what Dr. Ray's got is a whole bunch of MFTs underneath her. And they're
Yeah.
really doing she's got like 15 or 16 of them working on their doctorate or working on hours, and they're seeing all the patients. And she's
Mhm.
doing more of the MMI reports, the initial exams, the fit for duties, and then they're doing the weekly, the day-to-day stuff.
Yeah.
And you know what the claims team thinks is they're too lenient. She finds everything industrial, and that Dr. LaPalooza, but he has more of a forensic mind, right?
Yeah.
So
Yeah.
his is more like 50-50. He might find it work-related predominantly, or maybe not work-related predominantly. Whereas they feel, and this is just perception, that Dr. Ray kind of accepts everything. That's not really true, but that's what they think. That she has a more lenient bent, I guess,
Yeah. Yeah.
in her philosophy.
I have to admit, I and not that I don't like her, but I just feel like I get a little bit more concrete reporting from Dr. LaPalooza.
Yes,
Yeah.
he's
And
really a great report writer, and I'm talking fantastic. And I think he's limited. I think he only does work for us. He was only doing work for us and Zenith, but I think he told me he's not doing work for Zenith. He doesn't enjoy. They now are in this enviable position, right, Tara, where they can pick and choose who they want to work with, what work they do, because there's so much work. There's more work than there's enough providers to do it.
Yeah. Well, I know, I mean, I sometimes feel bad, because I have always continued doing some one-on-one work, and I have several EAPs who will reach out and say, can I take a case? And it's like, and so there's some I'll almost always accept the and work with health advocates. It's usually only 3 sessions get authorized, and so or they're mandated work referrals, and then I like working with veterans, and so I still take VA work. And so it's sort of pretty selective. And if people don't like my online approach, with scheduling and all that, then it's like they're not the right person for me.
Yes, you got to find your level. You got to find your fit. Well, and that's what Evernorth told me. They said we have lots of different people that we contract with because they're a wholly owned subsidiary of Cigna. That's their parent company. And they said we have lots of MFTs and different, not all the EAP providers are not typically, I think, clinical psychologists or psychiatrists. I think they're all MFTs, and they have a lot of them, right? But they said the reason they have a lot of them is because you got to find your fit. It's not just geographic, it's whether it's virtual, because some people only do virtual. And the one gal, the psychologist, I think that's at Lake Medical Group, because she did an emergency for me a couple weeks ago, and she said, I only do virtual care. I don't see patients in the office.
I don't either. Yeah.
She goes, I used to, but I don't anymore.
Yeah. Yeah. I had one employee who signed up with me, but then, she said, I hate virtual. I said, well, then maybe you should find another provider. She goes, it was hard enough finding you, and I said, I don't even have an office you can come to anymore,
Yeah,
And
there, I was gonna say there's not a place, so that wouldn't work anyway, right? And maybe that's the gal at virtual. She sees patients through Lakeview Medical Clinic in San Marcos, but I don't think she's at Lakeview. She might, you know what I think, Deborah, she lives somewhere else.
Hmm.
She could live
Yeah.
wherever, right? Because she bills under them and their tax ID, and they have some relationship with her. And then she sees work comp patients through them. Dr. DeLucas, who I really like, and she's really nice.
Okay.
But it's only virtual. There's no other option. And some
Yeah.
employees want to see the person face to face. And I don't, you know what I think? She never says this. I don't think she's
Mhm.
physically here. I think it's more like you. I think she lives.
Yeah.
She could live in
Yeah.
Hawaii, right?
Yeah. Yeah.
Like,
Yeah.
she could
Yeah.
live wherever, because
You know
now
what?
you can do that, right?
Yeah. And I quite honestly, I've been at this for a long time, but I feel it's just as effective
You
virtually.
think it's just works
And
just as well? Yeah.
I do, and when I think, then I'm factoring in too, I was trying to get people to do this, several years ago, even before
Before
COVID, because
COVID.
people would want to schedule late in the day, to not miss so much work or early evening, and I would accommodate them, but then they were always stuck in traffic. And so by the time they got to me, they'd have like 10 or 15 minutes left, and I couldn't see them any further.
And I always
So
think it would really help with like this Sweetwater, very difficult patient, because maybe virtual, they're not in the office. But the problem with that is these forensic reports require testing. And that I don't think you can do virtually in order to test and make sure the environment is good for that. Dr. LaPalooza and Dr. Takamura want them physically,
yeah,
eyes on
yeah.
them there.
Although I will let you know is that like the MMPI and other things like that are available now, and you can virtually proctor them.
Yeah, that's what I thought. The technology's got to be available, right, Deborah?
Yeah,
Because
yeah,
my
yeah.
daughter did, like, COVID hit while she was in the middle of her doctorate program, and she went to
Mhm.
school sometimes, but she did a lot of her testing and a lot of her things proctored virtually. So
Mhm.
I know that
Mhm.
there's technology to
Yeah.
do it, and
Yeah.
COVID kind
Yeah.
of,
I mean, we always used to be in person, but again, what we were going to do during COVID, and I usually do administer the MMPI when I'm doing my expert cases. And
Mhm.
in fact, I had problems this morning because they had changed the process, but I ended up having her go ahead and complete it without me proctoring because we lost so much time. They
Right.
had changed the process from the last time I'd done one, so it's like
no,
yeah, yeah,
yeah.
yeah. Well, good enough. Well, I'll reach out to you, about 10 days or 2 weeks before our next one, and we'll plan out our topics, but definitely the pregnancy and I'll look at some of the mental health guidelines because I know EEOC has come out with some stuff on that too.
Oh, good. Okay. Because that might be a good thing that we can do a little update on both of those for our September meeting. So did you already do all your summer vacations and you're back at it now? Yeah.
Yeah. I'm actually having foot surgery on Friday. And
Oh,
so,
really?
yeah. So, I'll
Down
be,
there in Mexico with,
no, back in
or
San
you're
Diego.
coming, oh,
Yeah,
you can
yeah.
make here.
Yeah, so I've got family and friends who'll be staying with me the first couple of weeks, so I have to really minimize walking.
Mm.
And but I plan to still work. I don't have a heavy schedule next week, but I figure it's on Friday, so I'll have the weekend to recover. I should be doing much better. I think I took
Oh.
Monday off. Yeah,
I'm
but I won't
sorry to
be.
hear that.
Well, it's something I've known I needed for many years, but the doctor kept
Oh,
saying, "Hey, if it doesn't hurt, don't do it." And I said, "Okay." And then I was going to do it in 2020, but then we know what happened then.
yeah.
And
What happened
I haven't
then?
had, yeah, but it has been bothering me more. It's a bunionectomy.
Yes.
So
Well,
it's
and
on
you're active, so I mean, that could interfere with your love of activities that you love, right?
yeah, yeah. And that's partly why I didn't do it before. And then also, I need 6 weeks, and I just could never take 6 weeks off, raising a family or working in
No,
person. But now it's like, okay, I can finally do this,
prop your feet up and do
Mm.
virtual because you just need your brain and to be able to communicate. You don't need to physically drive anywhere, and you
Right.
don't need to be in front of people with your foot up, right?
Right, right. I have turned down some in-person teaching opportunities because I don't even want to. I want this to go really well, so I do not want to be in any capacity where I have to stand.
Yeah, for a long period of time, which you would if you had to teach in person. Yeah. Oh,
Yeah.
well, I'll be thinking lovely thoughts for you on your
Well, thank you.
recovery with
Yeah,
that.
yeah,
Feet
yeah.
are important,
So,
right?
pardon?
feet are important, right?
Very, very much so. At first, I didn't know was the foot causing the back problems or the back problems causing the foot problem. And because it turned out I had a couple different issues going on with my left foot, and it turns out that I did have an epidural in my L5
Oh, okay.
back a couple weeks ago too, and so that did resolve. I was having a lot of pain, arthritis, because I was
Yeah.
having a lot of pain, but it was causing numbness in my left foot. But I thought the numbness was from the laminectomy. Only I
Yes.
found out no, it's not. It's from the L5.
Oh, it's a combo of
Yep,
things going on. Yeah.
yep, yep, yep. As we were talking about, mental health and the woman that that's having the treating, this is a really messy case, and we did the IPM I think last February, and this employee had been off for several months, but prior to that, with COVID and then I think her father had some health issues, so she left unexpectedly a couple different times to be with him, and we all get that.
Yeah.
Um,
Right.
and in the meantime, they also had a new dean that came in. This is at a community college, actually.
Mhm.
And um, and he's like, well, who is this person? Why isn't she here? And so because she just sort of did things on her own without really getting
Oh,
clearance. And
without getting permission.
yeah, and
Which means they were
and then
letting her do that.
it also turned out that she and the former dean were not following policy and getting pre-approval on overtime. And so she was submitting overtime after the fact. And in her absence, it was discovered that she was claiming overtime for time that she wasn't even there. And it's been a big, messy issue. And the people that were in charge at the time, both in human resources and department, are no longer employed.
Yeah, because that has to be approved by multiple people. So that means
Yep,
multiple people were involved in that little scam.
yep.
That's
And
not,
yeah, and so so a lot. They didn't say it wasn't. They felt there wasn't enough information to really do anything
oh, to
legal
discipline
against her.
or to
Yeah,
terminate her based
and
on.
yeah. Meanwhile, it's really harmed the relationship between her and her coworker. And
Yeah.
then because of her unexpected absences, and it was right at the start of the school year, it just, people were understanding, but at the same time overworked, overloaded, and just poor communication on her part about what was going on. And so things have been really strained. And so she got, and at one point she even got another job at the University of Reno,
Oh,
but was still
really?
employed. It was still employed at the same college. And so how could she be working in two places? And it
Is
turns
it,
out that the college doesn't have a real clear cut policy, whereas University of Reno does. And when Reno found out she was still employed down here, they fired her.
mhm.
And so then she went off work for about 6 months, and because she was claiming stress and all this, why she wasn't referred for a workers' comp, I don't know. And
Oh,
so she wasn't. And so when I did the IPM, coming back from this, non-work related stress period, we attempted to get information from her treater, her therapist, who said that the only thing she needed was natural lighting, because fluorescent lighting would contribute to her depression and anxiety. And so she
oh,
really
because of
manipulated.
like vitamin D that she needs,
Yeah,
outside light.
yeah,
It's kind of
yeah.
hard to do in a classroom. I don't
Well,
know.
she's not in the costume. She's actually an athletic trainer. And so
Oh,
they move
okay.
around anyway. Yeah.
Yeah,
And
so she'd get plenty of natural light, I would think.
well, you'd think, but so
Yeah.
anyway, so she was allowed to pick which of the two facilities that they have she's going to go to, and she chose one where she ends up being isolated. So when I did the IPM, I said, well, it sounds to me like the workplace relationships really need to be addressed, to facilitate a safe return for her to go back to work. And the human resources just jumped on that, and they said, do you do that? I said, well, yeah, but that's not why I'm recommending it, but it sounds like if she just goes back into the same workplace, she's likely to exacerbate her condition. But then they said, no, you know the case, we'd like to have you do it. So I've actually been working with these two employees. I interviewed everybody.
Mm-hmm.
But I actually worked with these two employees to do a mediation, but they are so polarized. Now there's a new dean. I'm not getting any response. Some of the decisions need a
Approval.
dean's direction on how the department's going to run. and roles and responsibilities. I had just learned, though, that they are planning to hire a new athletic director over these trainers, which had
Oh,
never
okay.
been there. And so it's just been a mess, but I'm feeling that, that she should have been referred for workers' comp, but I don't know why it wasn't done.
So there's 3 criteria, and you're right, it gets missed all the time, even by our school districts. Work is making me sick. Either a person at work, my supervisor at work, the workload at work, students at work, my essential job functions at work are making me sick. That's number 1 criteria. Number 2 criteria is I need to see a doctor, meaning I'm so sick, I need treatment. I need to see somebody. So it needs, we need to be there, or I need to take time off work. So it sounds like you've already met the criteria, and that's just the criteria we give you a claim form. Now that should have been done within 24 hours of their knowledge of those things, but of course it could be done at any further point down the road. Now, I don't know, and work is making me sick. Number 1, it's not, I don't feel good, or, I'm stressed out or whatever. It's work's making me sick, but it can be my boss at work, my coworkers at work, or my workload at work. But those are the things. And then that gets missed all the time. It all the time.
Yeah.
Because
Okay.
they
So I
don't think
think
about that as a work comp injury.
Yeah, I think I'm going to have that conversation because, we haven't been successful, and I've had 3 mediation sessions with them, and I reached out to some of the other employees, say, hey, has anything changed? Have you noticed any difference? And one was highly critical about the main employee as far as how she's, just outside her boundaries all the time. And yet she's feeling like she's cut off and isolated from the rest of the team. And yet she works in a different facility. And so it's like, it's sort of like, well,
That's kind of your fault, right?
yeah,
Well,
yeah.
and if they give her a claim form, she doesn't have to fill it out, and she doesn't have to file a claim, and she doesn't have to go into the comp process. She can stay. They can't make her, but they are supposed to give her a claim form if they have knowledge. It's 24 hours of your knowledge of work-related stress that's rising to the level of they need to seek treatment, which I'm assuming this person's seeking treatment, or needing to take time off work. That's how I'm assuming.
Well, so that's the thing, is that
You're not treating with anybody.
Well, we had a original note that was rather, well, it was timely at the time, but then we asked her for a follow-up in the spring, because I said, I knew enough to know that she had badly been abusing the accommodation that was provided. And even though the doctor's note said valid through the end of this calendar year, I said that doesn't mean that we can't get updates, because in the school environment we need to almost evaluate every year, depending, and we need to get ready because things are changing. And if I recall, she just provided an old note again. And so it's just like,
so you don't really have any current medical information on her.
Not really. And whatever it is, it's pretty vague.
Yeah, that she might not be seeking counseling. Because if you're not in treatment, you can't really claim a psych stress injury. You need to be at a level where you need to seek treatment for your injury, right? Like that's where it's risen to the level of that. That does need to be present. Because you can't file a comp claim, but you're not seeking any medical treatment for an injury. You're claiming an injury to your psyche, your stress. So you need to be treated. So that element needs to be there, if that's helpful.
Okay. Yeah, no, it really is helpful just hearing having another set of eyes on this, because communication with the college district has been challenged this summer.
Well, and if
my point of contact was off of work for personal reasons too.
And if they get a new athletic director, then maybe this person can come in and try to see with a new set of eyes if they can try to help fix the situation, whether that requires either, because they're going to have a new boss, right?
Yeah. So maybe that's why the dean was deferring. They even went back to the HR head and said, I really need some help on this. whomever is in charge needs to make decisions on how these two people are going to work together.
Mhm.
And I don't see one recommendation really working because it's going to create more of a divide. And that's
Mhm.
exactly what she's complaining. And yet, yeah, so it's complicated. But no, thank you for listening to that, and thank you for providing some input. That really helped.
Anytime. Yeah.
Okay.
Yeah.
Okay. You take care.
Yes, you too. Enjoy your day.
You too.
Bye. Nice
Bye-bye.
to see you. Bye.